Welcome to Case by Case. This is a podcast brought to you by Floyd Zadkovich. This is Carl Jane. I'm Luke Zadkovich.
Every episode, we read a case independently of each other. To jump on the podcast, we hit record. So what you get is our raw thoughts on that law.
And we're super excited with some of the guests we've got coming up on future episodes. So keep an eye out.
And if you like the podcast, all we'd ask is that you hit subscribe and share with your network. Okay, let's get into it.
Let's do it. Welcome to Case by Case. This is a podcast brought to you by Floyd Zadkovich. I'm Luke Zadkovich, and I'm delighted to be joined today by Ed Floyd and Eva-Maria Meyer, two of my partners in our New York office. Ed and Eva, how are you?
Doing very well here, Luke, and thanks to Case by Case for having us both on board.
Delighted to have you. I'm really pleased that you can both join. I'm only sorry that Callum Chain can't make it on the pod today because it's a big one. It's actually our 100th episode, and Callum was expecting to join but has been taken away on some very urgent injunction work in court. So, he will be missed, sends his apologies, but I think between the three of us, we've got more than enough to get into what is a super exciting case to talk about. So, yeah, do you want to give us a couple of words about what we're going to talk about today, Ed?
Yeah, just to tee it on up a bit there, and then we'll break it out further. But the case is HDI Global Insurance versus Kuehne Nagel, and it boils down to a question about the package limitation under U.S. Carriage of Goods by Sea Act, or COGSA, and it's an exciting one. During 2025, Eva and I handled a multi-day bench trial before the Southern District of New York on the case, prevailed there, and the plaintiff took that case on up to appeal to the Second Circuit, and earlier this month, that decision came on down, the mandate from the Second Circuit, and again, we prevailed. There's some really interesting context in there to work on through. Great decision, and also an important decision, if I may say so.
I think that's right, Ed. It's one of those decisions that when you look at the quantum, it's like, it's not that big a case by the standards of some of the cases we handle as a firm. But the principles involved are super important, and package limitation cases have a ripple effect across the industry because it's such a insurance-led kind of area. You have cargo insurers who have typically paid out the cargo interests who have suffered the damaged cargo. Those cargo insurers then step in on a subrogated basis and bring a claim against the NVOCC or the ship owner, depending on the case. And then the ship owner on the carrier side of things, they have their own insurance through P&I clubs for cargo damage. And so you kind of have this battle of insurers going on in these cases, which on either side, a decision in a case like this can then have this ripple effect across the portfolio. So a lot of eyes were on this decision in the shipping insurance world. And well done to you both for handling the matter, getting the win, and making some really interesting law on this. And I don't think we'll get into both, the facts of it, because those are important. I think it's actually maybe more important than appears at first appearance to understand the underlying facts. But this is ultimately a contract construction case. So we'll go through the canons of construction and look at how to interpret clauses like this and what have you. So, where would you like to start? I think perhaps the Second Circuit, the Court of Appeals decision, obviously it focuses on the legal analysis and the interpretation of the clauses. But before we dive into that, maybe we start at first instance and go through some of the background to the dispute and what we're talking about from a factual perspective.
Yeah, no, that makes sense. And I think Eva is probably in the best position to walk on through the factual background, and then we'll go back and forth a bit and may have some stuff to add to walk on through the decision itself. Just one side note there, Luke, you mentioned a lot of attention on it and an important decision. It was interesting going into the Second Circuit oral argument, which was remote, given some considerations at the time, a storm or something like that. And the number of people who reached on out beforehand and said, hey, we're listening on in. And it was definitely an event. A lot of people listening to it, a lot of attention to it. And the feedback we're hearing from others who have reported on this decision, there's been a number of articles on it already, is that it is automatically having a significant effect across the industry. But with that said, I'll pass to Eva to talk on through the factual background, if you'd like.
Thanks, Ed and Luke. Yeah, so I'll take it from the factual background and we'll develop from there. Like Luke already said, it seems kind of how important can the facts be, but they truly do play a role, and you see that kind of how you see how that plays out in the Judge Lyman's decision in the district court in the Southern District of New York. So starting from the top, it has to do with a shipment of 24 pallets that contain 480 cartons of electrical harnesses that were to be shipped from Barcelona, Spain to Charleston, South Carolina. And these electrical harnesses are used in HVAC units in cars. I was personally not familiar with electrical harnesses until this case, but you learn a lot of additional things than just law when you work on these cases. So the cargo was sold by actually a non-party, ECI, as mentioned already, to another non-party called Malver. And we're dealing here, of course, with the actual parties in the case, which were HDI, the insurance company of Mal, and Kuehne Nagel, which is the non-vessel operating common carrier, or NVOCC, that facilitated the transportation of the cargo. So the actual entities, ECI and Mal, had been working together for over a decade by the time this case arose, and fairly regularly, shipping cargo on a monthly, if not weekly basis. And their process there is pretty consistent. So ECI produces or manufactures these harnesses in Morocco. And after Mal places an order for the harnesses, they are put into cartons and palletized. And I'll get to the details of that in a little bit, in Morocco, and then are transported from Morocco over to Zaragoza in Spain into ECI's warehouse, where then they are ready to be picked up. So as to the palletization of the cargo, ECI doesn't just willy-nilly put these harnesses into cartons onto pallets, but they're actually following clear instructions that are previously provided by Mal. The document that they use is called a unit load data sheet. That's a bit of an additional detail, but they specifically say how many harnesses are to be placed into a particular carton, and then how many cartons are supposed to be placed onto a pallet, and then also how those cartons should be fastened onto the pallet. So this is extremely detailed, and these instructions are followed. And Mal does this to optimize the space in containers, so they can be easily moved with a forklift. It's more efficient, and also for the safety of their employees. So
Just pausing there for a second, Eva. I think this was a point that Judge Lyman kind of focused on, is that the cargo was, as you say, being put into cartons and then being put onto pallets in a certain way for a certain purpose. And it was actually at the request of Mal. And so there was this back and forth between shipper and receiver, and that had developed over time, as I understand it, from, my understanding is based on reading the judgments only. Because there was this deliberate process of putting it onto pallets and then packaged up on pallets, and that was for safety reasons, efficiency reasons. The judge kind of focused on that, and it was one of a number of points that kind of came out in the factual summary.
absolutely, yes, Luke. And the big word here, the important word here, is the convenience, right? It's done for the convenience of Mal, arguably also for ECI, but at the instruction of Mal. So the harnesses are prepared in this way, and then they are transported from Morocco to Spain, where they generally stay in this manner. The pallets aren't undone, the cartons aren't moved around. The cargo is palletized, and that's how it stays. Until then, ECI generates an invoice and a packing list, and then sends it to, in this case, it was K&N. And K&N then uses a process called green lighting, where it confirms with MAL that the shipment is ready and should be picked up. And then once MAL confirms that it should be picked up, K&N jumps into action, arranges for trucking for the cargo to be picked up at the warehouse and then transported to the port so it can be transported ultimately to the US, to Charleston. So that's been confirmed. The cargo gets picked up by the trucker. Again, it's a forklift moving the cargo from the warehouse into the truck. There's no changing of the packaging, right? It stays exactly the same. And then it arrives at the port. And once it arrives at the port, in this situation, it was a number of pallets that wasn't a full container load. So what happens then is that the cargo gets consolidated with other cargo into a container to be transported. And when I say consolidate, again, it's not opening the packages and changing kind of the constellation. It is truly picking up the pallet as it is, using a forklift and stuffing it into the container. There's no changing of the packaging at any point. K&N doesn't do that. So exactly that's what happened here in September of 2022. MAL ordered 19,800 electrical harnesses. It was a total of 4 separate orders. And they were prepared by ECI into 480 cartons in accordance with the instructions of MAL and strapped onto 24 pallets and with shrink wrapping, again, at the instruction of MAL. And then ECI issued the invoice and packing list, as it always does, and that was greenlit. And then K&N instructed the trucking company to pick up the cargo from the warehouse and to transport it to the port of Barcelona. So once the cargo arrived there, again, it was already palletized, so all that was left to do is take the pallets and stuff them into the container so it could go on its way over by ocean carriage to Charleston. Unfortunately, at that point, during the time of the loading of the vessel, the container fell into the water and the cargo was damaged. That is where this claim arises from, essentially the recovery of the damaged cargo.
Eva, I had a question, because you mentioned it in terms of booking the cargo in that description. When this type of trade is booked, is it booked on a carton basis, a pallet basis, a quantity basis, and then how is it kind of paid for on the other side? Like, how is that dealt with?
Are you wondering there, Luke, about the sale and supply from ECI, the manufacturer over in Morocco and Spain, to Malbert, or about the transportation?
I suppose I'm more interested in the transportation, but I was just curious to know how does the commercial side of this work? Like, are they talking about pallets? Are they talking about quantity? And I know that will filter through into the shipping side of it, and how the space is booked with the carrier, and then what goes on a bill of lading and what have you. But I was just interested, how does it work from a commercial perspective?
It's Eva will fill in further there, but it's a topic.
No, it's I'm not.
No. It's important to know
beyond the quarters of the judgment.
It's a topic that was addressed with a fair amount of evidence, both oral and testimonial and documentary, before Judge Lyman, and he was quite interested in the topic as well, and it works its way on into the district court's decision. The communications between the parties and the expectations overwhelmingly indicated that they were talking in terms of pallets.
Yeah.
All of the relevant documents, you're talking about the commercial invoices, the Seaway bills, and the packing lists. All of those included identification of the pallet count. Some other counts were on there and so forth, but pallet count was the one uniform item. And also when the parties went back and forth during the green lighting process that Eva mentioned, there was a lot of talk about pallets there.
Yeah. Okay. Sorry. I didn't mean to interrupt the flow.
It's all right. So I think we're actually at the end here. So the container has fallen into the water. The cargo's been damaged. HDI steps in as the insurer for ECI and files a claim against K&N to recover the value of the cargo. Now, that's essentially the facts that happened, how we arrived here. There's another really interesting and important aspect of what happened during this time that pertains to the star of the show, so to speak, which are the Seaway bills. And that's where we get into the contractual interpretation. Ed will take over from here and explain what happened there.
Can we start, Ed? I know plenty listening in will know what a Seaway bill is, but we do have, I'm really delighted to say, a diverse listenership with our audience and some that are non-shipping people. So what are we talking about when we refer to a Seaway bill?
Yeah, and let's actually, just in case there's some non-shipping people out there, let's step a moment away from even a Seaway bill and just talk about bills of lading to begin with. So you've got BLs, as the acronym goes, or bills of lading, used all the time for all types of carriage throughout the shipping industry. And a true bill of lading, I'll describe what it looks like. It can be as simple as a single page with some information on it, but it serves three purposes, right? It's a receipt for what's been provided to a carrier. It also functions as a contract of carriage. And thirdly, it can be a true bill of lading will be a document of title. And I know some would quibble and say, oh, it's evidence of the contract of carriage, not the contract of carriage itself. Whatever there, that's a distinction that doesn't play into the situation here. But those are the three functions of a true bill of lading. For a Seaway bill, sometimes also referred to as liner bills, they serve two of those functions. They're going to be a receipt. And that's something that we should talk more about here because it plays into Judge Lyman's decision. And it's also the contract of carriage. What it is not a document of title. And many Seaway bills, when you see them, will expressly state, I think they uniformly state, this is not a document of title. That gets into trade finance and so forth, whether or not one wants to be able to take it, go to a bank or a financier and finance a trade. There's some other purposes there as well, pledging and so forth. But that's what
There's also just a short tangent on that around a Seaway bill not being a document of title. What that means is you don't need to physically deliver the piece of paper to get your cargo off the ship. All you need to do is establish that you are the consignee. So you need to show some form of authority that you have authority to receive that cargo from the carrier. And that's obviously important in line of business because you have so many containers on board. It's kind of unwieldy to have every container or part of container, or a collection of containers requiring the original bills of lading and having them handed over. So having a system where you can establish who you are and that you're entitled to those goods through identification rather than the physical document has a convenience factor. Sorry.
No, most definitely does. And then there's also a legal factor to keep in mind, statutory consideration, which is COGSA. And again, for anyone listening, hopefully you are not listening, who's not from the shipping industry or familiar with these terms. COGSA is essentially, it's a U.S. statute that adopts, to keep it simple, the Hague rules regarding carriage of goods by sea. An important part of that, other aspects are covered, but is limitation of liability for the carrier. And COGSA applies where a bill of lading or other document of title is the relevant contract. And a Seaway bill, as we were just covering, is not a document of title, nor is it a bill of lading. So COGSA does not apply by force of law automatically to a Seaway bill. The fancy legal Latin phrase, ex proprio vigore. So what you routinely see happening with Seaway bills is that they will expressly adopt COGSA, incorporate COGSA for purposes of U.S. trade, that being trade to, from, or through the United States, and For non-U.S. trade, they will incorporate alternatively either the Hague or the Hague vis-a-vis rules by default. And that's an important consideration to keep in mind. I'll get more to that, but talking about these particular bills of lading, these particular Seaway bills, they're not very different from any others that are out there. 2 pages, a front and a back, sometimes called the front and the reverse. On the reverse, you have some standard terms and conditions, 1 through 21, as I recall. On the front, you have a bunch of boxes, and these look like most other Seaway bills and bills of lading. At the very top third of the page, you're going to have the basic information: who, what, when, where, and why. 5 W's. It's going to show who's the shipper, who's the consignee, if there's a notified party, who's the notified party, what's the name of the vessel, etc., date of pickup, and that basic information. In the middle third, under a big, bold header that says something along the lines of particulars furnished by shipper, carrier not responsible, you have several sub boxes. And amongst those are going to be a sub box that says something like number of packages. And next to that, it's going to say description of goods. And further over in that middle box, it's going to say receipt and words along the lines of carrier confirms that it has received the following in apparent good order from the shipper. And then it will say, turn to the reverse to read the terms and conditions, all of which are incorporated, blah, blah, blah. And the last thing to cover off from the front of the bill of lading is that the Seaway bill, as will such Seaway bills uniformly, it's going to have another box down the bottom third that provides an opportunity for the shipper to declare a higher value, because otherwise the bill of lading does not deal, nor does a Seaway bill, with the value of the cargo. And there's an opportunity on the front for the shipper, the cargo interest, to say, here's what the cargo is worth. And if they do that, they trigger that, then there's a negotiation process with the carrier to agree upon a higher freight rate.
And in the actual decision, Judge Lyman's decision on page 11, page 11, there's actually a screenshot dropped into the judgment of the Seaway bill in this case. And you can see the columns that Ed's referring to, the number of packages column, the description of goods column, and the space down the bottom that has where the declared cargo value could have been declared, and there wasn't in this case. So if you're interested in kind of visually what this is looking like, you actually see part of it in the decision itself.
So what this case got to ultimately, and the core issue there, because the parties going into the bench trial had agreed that there was a sole issue. What is the proper count of packages for limitation purposes? And what that largely turned upon, plaintiffs, HDI, were saying, Your Honor, on the front of the bill of lading, in the column that says number of packages, it has a number which is greater than the pallet count. They didn't want to get into too much that right above that, it says particulars furnished by shipper, carrier not responsible. But they wanted to focus entirely on that number in the front, on the front of the bill. But you flip over to the terms and conditions, which were fully incorporated. And in those terms and conditions, it's got some great language, really explanatory language specific to the COGSA limitation of liability role. And let me just read that. In 6.1c of the terms and conditions, it said, neither the carrier nor the vessel shall in any event be or become liable in any amount exceeding $500 per package or customary freight unit for limitation purposes under COGSA. Here's where it gets important. It is agreed that the meaning of the word, quote, package with a lowercase p shall be any palletized or unitized assemblage of cartons which has been palletized or unitized for the convenience of the merchant, regardless of whether said pallet or unit is disclosed on the front hereof. So that clause that I just quoted from the standard terms and conditions versus the number shown on the front of the bill of lading is essentially what this dispute was all about. And the trial court, I would say that its main holding was that it looked at that language and reads it in the context of the rest of the contract of carriage and says there's no ambiguity. It's clear and unambiguous what is meant here. It's talking specifically about U.S. carriage and what the applicable limitation of liability will be and how you determine what the package is for that limitation of liability. It's clear on its face. Pallets were the applicable package for limitation purposes. But then where things get interesting is the court goes through the other arguments that were raised by HDI and really gives force to this holding. First and foremost, there was a consideration that the word package with a capital P, remember that I said when I read the quotation here beforehand from the limitation clause, it was lowercase p. But the word package was included within a definition elsewhere in the standard terms and conditions. And capital P package was defined as being a range of different containering items. It might be cartons, might be boxes, might be pallets, et cetera, but it was defined. And it referred as well to the front of the bill of lading. But the court looked at that connection and said, wait a second, this defined term package from the standard terms and conditions with a capital P, that capital P package is only used in one other spot, and that's in connection with the opportunity to declare a higher value. Remember that when I was talking about the three different sections of the bill of lading, you got down at the bottom, the opportunity to declare an ad valorem, to declare a higher value and pay an ad valorem rate. That is where capital P package was used in connection with. Then the court also dealt with an argument that bills of lading and seaway bills are inherently contracts of adhesion, that people don't have the opportunity to bargain, et cetera, et cetera. But the decision by Judge Lyman looked at that argument and said, there is a bit of an opportunity to bargain here. You could make use, the shipper could make use of the opportunity to declare a higher value. Additionally, so that goes to the bottom third of the front of the bill of lading or seaway bill. Additionally, the particulars, the middle third of the seaway bill, were furnished by the shipper. And if one looks at COGSA, I think it's COGSA section 3.3, the carrier, the non-vessel operating common carrier, has an obligation to put the information furnished by the shipper onto the seaway bill. And Judge Lyman's decision looks at that and says, wait, that would give unilateral power to the shipper and the cargo interests to determine what must be put on the front of the bill of lading and thereby what the liability exposure for the carrier would be. So that is the real adhesion contract argument there. The position being advanced by the cargo interest, by the subrogated insurer here, would have enabled cargo interests to have unilateral power to set what the carrier's limitation of liability would be. And so the Southern District was not going for that argument either there. But ultimately, the whole decision turned on the language in 6.1c regarding what would be the applicable package for purposes of U.S. carriage when there was a pallet. It said it's clear as day. It's the pallet that matters.
Before we get onto that and unpack that a little bit more on the language, there was this factual point that I saw about how the data was entered into the C-log system, and that the 200 packages or whatever the number was that was put in the column for number of packages actually had another purpose to do with customs declaration, and that the system only had one way. I think customs wanted to know what the lowest type of package was to assess customs duties. And that number had to be entered into the system. I think that's the number that then tracks through into the column number of packages. It wasn't necessarily a designation about, well, this is the number of packages for package limitation purposes. And as I mentioned earlier, when it came to looking at how the cargo was treated from a commercial perspective, the weight of evidence was clear that the freight cost here was calculated on the basis of pallets, and not related to individual cartons. But I thought the judge, it's not ultimately why the decision went the way it was, but these factual considerations kind of, I think, set the platform for the legal interpretation. And one of the takeaways that I had from this, again, I wasn't involved in the case, but just having read the decision, and I'm not looking for you to comment necessarily on your legal strategy, but just having read this, I think it was a very neat way of presenting the case from a factual perspective. It had a bench trial. This wasn't just a decision alone on the wording of the contracts. There was actually evidence led here before the court as to how the parties set up this shipment on the documentary side, how they paid for it, as Eva explained earlier, how the whole trade underlying worked. And there were a number of markers or indicators through that suggested that the package was the pallets, and the pallets as a measurement, as a tool, was the most important on these various kind of facets. And so when the judge is then asked to look at, well, there's a simple statement of 200 packages in the column for number of packages, surely that's what should be the package limitation number. The underlying facts then kind of set up this position that makes much more sense to say, well, hang on, let's look at the other clauses in the contract. And even if there's a designation in the number of packages, that can be rebutted by the contractual language and through other facts, around it.
Yeah,
I think that makes sense. There was definitely emphasis by Judge Lyman on the underlying relationship between the parties. Like I mentioned, they've been doing business together for over a decade at that point. There, of course, it's a situation where Seaway bills are not, they don't operate in a vacuum. They might serve different purposes. I'm sure Ed will go into this further later on, but they're standard documents, right? So they might also serve different purposes for different shipments, and they kind of need to function wearing different hats almost, but looking the same throughout. I think one point that is important to note is this point of, okay, the number of packages column, and clearly from our discussion, that carries a lot. The number in the number of packages column carries a lot of weight, and that comes from somewhere, right? That's the precedent that we were working with in this case in the Second Circuit. It's a 1991 Second Circuit decision. It's Seguros. It also shows that this topic hasn't been in the Second Circuit for quite some time now, so making this case unique in that way as well. But that decision sets the groundwork for the analysis that Judge Lyman had to perform when looking at this. And it starts off with this question, or this rule, or this consideration that the number appearing under the heading of number of packages is the starting point of the analysis of what are the packages that for COGSA limitation purposes, right? What is the number times $500 that would get you to the limitation in a given case? And so a lot of the time when you're looking at a Seaway bill or also a bill of lading, there is a number of packages column, and it might say in 120 packages. Okay, well then you would assume, just reading that part of the instructions given by the Seguros case, that number is the number times 500. That's the end of the analysis. But that's not where the Second Circuit in Seguros stopped, right? So it then goes on to say, if the significance of that number in the number of packages column on the front of the bill is plainly contradicted, and clearly there's an intent of the parties somewhere that shows that the number in the number of packages column actually is not supposed to be and not intended to be the number for the calculation of this limitation under COGSA, then that should be considered as well. It is only the starting and ending point of the analysis that is the number in the number of packages column, if there is no such other evidence that plainly contradicts that should actually be the calculation, and that's what the parties intended. So that's how the judge and Judge Lyman had, in normal contract interpretation way, actually had to read the entire contract, right? And that was an argument I think that the plaintiff tried to make is, well, you've arrived at the number in the number of packages column. It says 120, and that's in one of the Seaway bills where there were a total of 4. And that's all you need to read. You don't need to continue to read the rest of the bill, actually, because you have your answer right there. And obviously that's not right, and that's not what Judge Lyman ended up doing. It's how we end up interpreting and looking at the reverse, like Ed mentioned before, at this language and the consideration of whether or not the number in the number of packages column is clearly contradicted by this language on the reverse side of the Seaway bill.
And I would add to that, though, a key thing in getting that point so that the court was in a position that it could make that determination was showing the function for all of the other pieces of data on the front of the bill of lading. Luke, you mentioned the connection to customs clearance considerations, and the court dealt with that very nicely, neatly, which is that the data systems for entry of information that ultimately gets spit out in the form of a bill of lading was set up in a manner to be sensitive, as the court put it, to customs requirements. The customs requirements say for submission of a manifest to U.S. Customs and Border Protection, identify the lowest number of externally visible units. And so dealing with transparent shrink wrapping over a pallet which had cartons packed on top of it, the externally visible lowest count would be the number of cartons. So that information, that count, had to make its way into inbound manifests ultimately. And the data systems were set up in such a way that one could only put numerical information, make numerical entries in the box dealing with number of packages on the front. But one could use alphanumerical free text in the description of goods box there. So the data systems were set up in a way to be sensitive to the customs requirements, and they serve that function. Another function that box on the front of the bill covering number of packages was found by the court to serve was that personnel at mall, when they received things, needed a place to look and start counting. So it served a number of different functions, and all of those functions were established before the court.
Yeah. So look, anything else that you want to mention about Judge Lyman's decision? I think that it kind of neatly brings us through to the Second Circuit decision. Anything else before we move on?
No, I think we're, Eva, I'm feeling good to go on that.
Yeah.
Yep, I like it to move on.
So we've the cargo insurers HDI appealed this to the Second Circuit Court of Appeals, and we had circuit judges Denny Chun, Raymond Lohier, and Stephen Menashe sitting on the Second Circuit. And as mentioned before, Ed and Eva handled the advocacy in the Court of Appeals. And yeah, the decision of Judge Lyman was affirmed. Now, this decision doesn't need to traverse and didn't traverse all the facts that had underpinned Judge Lyman's decision. They really looked at the legal question de novo, so afresh, and focused on the interpretation analysis. So, would you like to give us a snapshot as to how the Court of Appeals dealt with this?
Yeah, I think the Court of Appeals, as one would expect, really went straight down the middle on this one in terms of focus and cuts to the chase. The takeaway of the holding was, as I would see it, it's a maritime contract. It's interpreted, understood, construed according to federal maritime law, unless issues are inherently local, in which case one might consider state considerations as well. But this was not one of those situations. If the contract is unambiguous under maritime law, and I think any other bodies of common law out there, then you discern party intent by the words that they've chosen to utilize, and the words that were utilized by the parties in this situation were clear cut. Pallets are the packages. And so I would say that the Second Circuit went straight down the middle there and made this determination. Of course, it dealt with some of the contrary arguments about adhesion and so forth that had been raised by the other side in prior precedent, but the Second Circuit was not inclined to blur the distinction that it's drawn previously between so-called container cases and the non-container line of cases. And what I'm getting at there is the Second Circuit has in the past been reluctant in COGSA cases, has been reluctant to give effect to contractual clauses that would identify the container, meaning the big metal box, as being the package. But they have also very, very expressly stated that container line cases and non-container line of cases are two distinct areas of maritime liability law, and they don't want to see those get blurred together. And so with respect to the non-container line of cases, such as the pallet case that we had here, whatever the parties have agreed to in clear and unambiguous language as set forth in the words they've chosen to use is what's going to apply. And I think it was a great decision, of course, by the Second Circuit, and worked a good result for the whole industry.
Yeah, I completely agree. It was very clear, succinct, and gets to the point, as you'd expect. I also like that both Judge Lyman and Court of Appeals looked at the clauses in a way that sought to give every clause in the contract some meaning. They didn't just necessarily say there's a conflict here between clauses and one's knocked out and the other one applies. They found a way to interpret all of the contractual clauses on the Seaway Bill to have some effect and some meaning. And I think it's one of those operator guidance points, is that just because there's a clause sat on the reverse side of a bill of lading or a Seaway Bill, seemingly in small font on the back, it doesn't mean it has any less bearing than other clauses. And indeed, some clauses on the front have been drafted by one party without approval of another party necessarily. And so, yes, Eva's quite right in setting out that what's set out in the number of packages column is the starting point. But if there's then other clauses in the contract or other facts that can be used to rebut that, then the court will consider those. And look, the clause 6.1c on the back that dealt with package description and talking about cargo that's been palletized was very clear. It's it's clear, and it kind of makes sense in this business too. It's not like there's a description of, well, if cargo's palletized and then what was actually happening in the real world didn't really have pallets, or the pallets were used for part of the shipment but not carried all the way through. No, this cargo was packed on pallets at the outset, was moved in pallets, was paid for as pallets, was booked as pallets. It got to the destination in pallets, and it wasn't until it was at the consignee's warehouse probably that the pallets got taken apart. So from a shipment perspective, pallets were really the key shipment unit here. I think, though, why this case has attracted so much attention and will do is because it would not surprise me in many instances, perhaps when these cases are dealt with, and there are some cases that are low in value and what have you, at an insurance level where claims have been paid out on the basis of the number that sat in the number of packages column, when actually there are arguments to be had here about the pallet maybe should be considered as the package. And this case kind of really emphasizes that point. I'm not saying that that was standard practice or anything across the industry, but I could see how, at first blush, just looking at a Seaway bill like this, seeing the 200 packages in that column, say, okay, yeah, that's the count for the package limitation purposes, without digging into it and saying, well, hang on, were they carried in pallets? And yes, then that pulls in clause 6.1c on the back and so on. So it's been a great case for the firm to be involved in. Well done to you both. And I know we've had a number of questions on this, and as you say, it's been written about by plenty of others out in the industry. So thanks for coming on and sharing your experience and thoughts on the decision, Ed and Eva. I'm sure the audience have enjoyed listening to you. And thank you to everyone who's listened in. If you've got some questions on package limitation issues, there you've got a couple of attorneys here that have been in the depths of it at two levels of the US court system. So thanks for listening in, and we hope you've found this podcast useful. Any final remarks?
Not at all. Thanks for having us on, Luke, and always a pleasure. Hopefully get back for another case by case soon.
Thanks,
Thanks,
Eva. Good to have you on. Okay, see you everyone. Take care.